We're going to talk about how to pass your rental properties that are inside of an LLC down to your kids without hitting them with a large tax bill. You've worked hard to build up your rental portfolio and the cash flow from that to take care of your family. So the last thing that we want when you pass away is for those assets to get frozen. You spent years building up your rental portfolio and the cash flow to take care of your family. The last thing that we want to have happen when you pass away is for your family to get locked out of those properties, them get stuck in the probate process for years, and for them to get hit with a large tax bill when they inherit that portfolio. The good news is that if you keep your rental portfolio inside of an LLC and you structure it correctly, your family can take over that portfolio immediately when you pass away. It will not get stuck in the probate courts for years, and they will not be hit with a large surprise tax bill when they inherit that portfolio. So let's talk about some of the ways that we can structure this. The first thing we need to cover is what is a step up in basis. So this is going to be the IRS's starting line for measuring your profits for the assets. If you purchase a rental property for $200,000, that's going to be the starting line or the basis. And then later, if you sell it for $500,000, there's going to be a $300,000 profit there. So it's $500,000 minus the original $200,000. So when you pass away, the IRS will give your heirs a new starting line. The starting line for your heirs is not the original purchase price of your properties. It resets to the fair market value of that asset when you pass away. So if you pass away and it's $500,000 and your original purchase price is $200,000, the IRS will give them a step up in basis to the $500,000. Meaning if they sell that property immediately upon your death for $500,000, then they won't pay any capital gains tax because they had a step up in basis to $500,000. So basically this means that your kids will not have to pay capital gains taxes on the growth that happened while you were alive. So let's talk about how a step up in basis works when you have your rental portfolio inside of an LLC. Owning rental properties inside of an LLC is going to be different than owning those rental properties in your personal name. So when the properties are inside the LLC, you don't own those properties. The LLC owns those properties. All that you own is the membership interest of that LLC, which is basically shares of that company. And so then when you pass away, your children are not inheriting the rental properties. They're inheriting the LLC and the membership interest of that LLC. And so the membership interest is what gets a step up in basis, not the rental properties inside of the LLC. And so the way that you get around this is going to be the Section 754 election. So the IRS allows you to have a special move called the Section 754 election, which allows the properties inside the LLC to receive a step up in basis when you pass away. And so without the 754 election, your kids will still inherit the membership interest of the LLC, but they will lose valuable depreciation that is occurring on those properties, and they will face a larger tax bill when you pass away. But with the 754 election, they receive the full tax benefits for the LLC being passed down to them. So let's talk about how the fair market value of the LLC membership interest with the rental portfolio inside of it is determined. Now remember that we are not passing the rental properties down to them, we're passing the LLC membership interest down to them. So when we pass that down to the kids and they need to figure out the fair market value of it to receive their step up in basis, this will explain how that process works. So basically what happens when you pass away is that the manager of the LLC will have to get an appraisal on each of the properties inside of the LLC. And then the appraiser will take the value of the properties inside the LLC minus the debts of the LLC, which would be the mortgages and any other loans tied to that LLC or the properties inside of it. And that will give the fair market value of that entity. And then they will take special considerations into play. So as an example, if the shares that you pass down to your kids are non-voting shares, meaning they have no control over the LLC, that will be worth less than actually having ownership of the LLC with voting rights because they don't have any control. So now that we understand what the step up in basis is and how it applies to the LLC that holds the rental portfolio, let's talk about the different ways that we can pass the LLC down to our kids. The first one is going to be using a will. So basically all you're doing is listing that LLC membership interest inside of your will, and then when you pass away, what's going to happen is that LLC will have to go through the probate process to be distributed out to your family, them take over the ownership over and therefore the control. The problem with going through the probate process is that the membership interest is effectively frozen during probate because your family does not own the LLC, the estate owns that LLC, and the only person that has any control over the LLC membership interest is going to be the executor of the estate, and they have limited authority on what they can do without getting special permission from the court. So basically any major operational decisions that need to be made with that LLC will have to go through the courts or it will be left unmade. Therefore, it's going to affect the operations inside the LLC and the ownership tied to it. So basically the LLC will go down to your family, but it's going to go through the probate process, which slows everything down in terms of the ownership of that LLC. Another way that we can pass this down is using a revocable trust. So what we do here here is we take the LLC membership interest, we transfer it out of our name and put it into the revocable trust. And now the trust owns the LLC membership interest, but because it's a revocable trust and you can be a trustee and have full control over the membership interest while you are alive. And then when you pass away, the LLC will avoid the probate courts altogether. And then you have two options on how you can structure it. Either you can keep the LLC inside of the revocable trust and have your backup trustee manage that LLC on behalf of your family, or you can distribute the LLC directly out to your family. The main benefits here are going to be that your family can take over the ownership without having to go through the probate courts. If they don't have to hire a probate attorney, you can save them $5,000 to $15,000, and the probate process is going to take 1 to 2 years, so you can cut out most of that timeline. And you can still maintain the tax advantages of this. You'll still be able to get the step up in basis when you distribute those assets out to your beneficiaries, and they can still do the 754 election on the rental portfolio inside of the LLC. So generally, most people are going to choose this if they want to avoid the probate process and maintain the full tax advantages of when passing that rental portfolio down to their family. So let's talk about an example of how all of this math works so you can wrap your head around everything. So let's say you have 4 rental properties inside the LLC with a total portfolio value of $2 million. You have mortgages across those properties valued at $500,000. And so the net value of the LLC is going to be $1.5 million. But your original purchase price of that portfolio is going to be $900,000. So at your death, your kids will receive a step up in basis on the $1.5 million value of the assets inside of that LLC. And then the LLC can make a 754 election, which will allow the properties inside of the LLC to step up to today's value. And then that step up can erase hundreds of thousands of dollars in capital gains taxes that would have had to have been paid. So let's talk about the risk associated with you not properly planning and structuring everything out correctly. So if you do not do the 754 election, your kids will miss out on depreciation and there will be a mismatch of the taxes. If you only set up a will and you do not have a trust, your LLC will have to go through the probate process. Those assets will get frozen during the probate process and they will not be able to collect cash flow during that period of time. If you do lifetime gifts of the shares of the LLC, those shares will not receive a step up in basis. If you do not get an appraisal of the assets inside of the LLC, the IRS could contest the value of those properties and hit them with a tax bill. So let's talk about a quick checklist that you can go through to make sure that your assets have asset protection, you're passing those assets down to them smoothly, and they are minimizing the amount of taxes that they would have to pay on that inheritance. So what you can do is put the rental properties inside the LLC so that any assets outside the LLC have asset protection. So what you can do is put the rental properties inside of an LLC, which will give you, the trust assets, or your children liability protection from the operations inside of that LLC. Then you can put the LLC membership interest inside of a revocable trust, and that will allow it to avoid the probate courts when you pass away. Then you can have your CPA file the 754 election for your LLC, and then order an appraisal of the rental properties inside of the LLC to get the fair market value of that portfolio. And then you can avoid gifting shares of the LLC during your lifetime if the goal is to minimize the taxes that your heirs are going to have to pay. If you want help setting any of this up, whether it's asset protection, probate avoidance, or anything else related to your rental portfolio inside of an LLC, click link in the bio, fill out the form, and schedule a time to talk to someone on our team.